Okay, so you've been following the whole situation with the 79th Group Limited, and you've shared some really crucial information with us.
That's right.
Today, we want to do a bit of a deep dive, really focus on their recent public statement. Our goal here is to kind of cut through the corporate jargon, get to the heart of what this announcement actually means for you, the investor.
Yeah, absolutely. We're zeroing in on that specific statement from April 10th.
The one they put out in response to the City of London police investigation?
Exactly. And, on the surface, these kinds of statements, they can often seem like, well, just routine updates. Business as usual, perhaps.
Right. Just keeping people informed.
But when you really start to unpack the language, look at the implications. Well, a potentially quite alarming picture starts to emerge, doesn't it?
It does.
It's not just about what they're saying, but critically what they're not saying, and what all that suggests about their current financial health.
And I think what really jumped out at us almost immediately was that this statement, it doesn't really offer much reassurance, does it? It actually reads more like an admission of, well, pretty significant financial distress.
That's a fair assessment, I think.
So let's start with a very direct quote they used. "We have ceased taking any new funds." Okay, let's unpack that. Why is that such a critical piece of information for a company structured like the 79th Group?
Well, that phrase right there, "we have ceased taking any new funds." I mean, that immediately throws up a major red flag.
Okay.
Because businesses operating on models, similar to the 79th Group, they often rely quite heavily on a constant flow of new investment.
Right, to cover existing obligation.
Precisely. To manage their existing commitments, think of it like a cycle, sort of.
Yeah.
New money comes in, helps pay out earlier commitments.
Okay.
So when that inflow suddenly stops, the entire system can come under some pretty severe strain.
Which, if you're a loan note holder listening to this, must be particularly concerning. Because if they're not bringing in new capital anymore, the immediate question is, well, where's the money going to come from? To cover the interest payments, the eventual redemption of your notes. It creates a real sense of uncertainty.
Exactly right. This stopping of new funds, it strongly suggests, a potential inability to meet their current financial responsibilities to other investors.
And legally speaking?
Well, from a legal standpoint, a business that simply cannot pay its debts as they fall due, it's considered insolvent.
Right.
This isn't just, a temporary cash flow problem. It points towards a potentially fundamental challenge to their overall financial viability.
They also stated, and this bit really caught my eye too, "We have asked for a moratorium on payments to clients." Now, moratorium, it sounds quite formal, quite official, but in plain English, what does that actually mean for you, the investor? Because I imagine hearing that word could cause a bit of confusion, maybe some anxiety.
Put simply, it means they've stopped paying you.
Okay, that's blunt.
That's really the practical effect of a moratorium on payments in this kind of context. It signifies an indefinite halt, a stop.
Indefinite.
Yeah, to interest payments, to redemptions. And what's particularly concerning here is the complete lack of a clear timeline.
Right.
Or any specific details about when, or perhaps even if, these payments will start up again. It just leaves investors stuck in limbo, really.
They do give a reason, though, don't they? They mention this is to develop a plan, and they're working with strategic partners. I mean, on the surface, that might sound like they're trying to find a solution, a way forward.
Might sound like progress is being made, yes.
Well, what's your take? Does it offer genuine hope, do you think?
Well, if we dig just a little deeper into that statement, it's remarkably vague, isn't it?
Yeah.
What exactly does this plan involve?
Yeah.
What stage is it actually in? Who even are these strategic partners? What's their role supposed to be?
And crucially, how long is this all going to take?
Precisely. There's absolutely no indication of time frame. And unfortunately, the lack of these essential details, it really suggests this moratorium might be less of a, shall we say, concrete strategy.
And more of a...
And perhaps more of a tactic, to manage the immediate fallout, maybe buy themselves some breathing room. A stalling tactic, essentially.
So going back to what you said earlier about insolvency, this moratorium, their admission they can't pay right now, it connects directly to that legal definition, doesn't it?
It does, yeah.
It's not just a financial hiccup. It carries real legal weight.
Absolutely. Under Section 123 of the Insolvency Act 1986, well, the law states a company is legally insolvent if it cannot pay its debts as they fall due. It's quite clear.
Okay.
So, by publicly stating they've requested this moratorium on payments, The 79th Group Limited is, well, effectively acknowledging their current inability to meet those obligations.
This is a significant admission.
It really is.
Yeah.
And it highlights a potential shift, maybe, in their focus towards internal damage control, perhaps, and maybe away from the immediate concerns and, importantly, the rights of their investors.
The statement also includes the line, "These steps have been taken to ensure that the business survives." Now, again, that might initially sound like they're thinking long-term, which could eventually benefit everyone, but you're suggesting this focus on survival carries a different, perhaps more worrying implication in this context.
Yes, I think what's particularly revealing there is the emphasis on survival as the primary objective. Rather than, say, focusing on restructuring for repayment or returning to profitability for investors. The wording matters.
Okay.
It signals potentially a fundamental change in their priorities. Mm-hmm. The company's immediate concern seems to be its own continued existence, its survival.
Which
strongly implies, unfortunately, a potential move away from fulfilling their financial commitments to investors like you, at least in the near term.
And this focus on survival you mentioned earlier can also connect to another aspect of insolvency law, something called balance sheet insolvency. Can you explain that a bit more?
Certainly. So focusing on survival often involves taking drastic measures, right? Like slashing overheads, restructuring operations significantly.
Trying to stop the bleeding, so to speak.
Exactly. And this kind of action can be a strong indicator of potential balance sheet insolvency. That's defined under a different part of the Act, Section 1232.
Okay, and that means?
That occurs when a company's total liabilities, basically everything it owes, exceed its total assets, everything it owns.
Yeah. Right.
So their current actions, focusing so heavily on survival and cost-cutting, suggest they might be in a mode of trying to minimize further losses, salvage what they can of the core business itself.
Rather than focusing on getting investors' money back.
Rather than prioritizing the recovery of funds for investors. That seems to be a secondary concern right now, based on this statement.
Okay, so if we sort of take a step back now and look at the whole picture painted by this statement, what are the key, maybe brutally honest confirmations we can take away from it? What has the 79th Group essentially admitted, whether they meant to or not?
Well, if we connect all these dots, the statement really confirms several pretty concerning realities.
Such as?
Okay, 1, they've stopped actively seeking new investment capital. 2, they've halted payments, interest, and redemptions to their existing investors. 3, there are reports coming out about staff reductions, cutting costs.
Right.
And crucially, for man, they haven't actually presented any clear, detailed plan that outlines how and when investors can realistically expect to be repaid.
So lots of negative points.
Lots of negative confirmations, yes. And while, look, the intention behind releasing the statement might well have been to manage the situation, maybe dampen down panic.
Yeah, control the narrative.
The underlying message, the hard truth, seems to be that time is now absolutely critical for you and for other investors.
Time is critical.
Their own words paint this picture of a company facing a really significant legal and financial crisis. This goes way beyond just a simple PR challenge.
Okay. Now, understandably, there's been quite a lot of talk and maybe hope among investors about the ongoing City of London police investigation.
Yes.
Many people might be thinking, okay, the police are involved. Surely this will lead to some kind of financial recovery, some restitution. What's your expert take on relying on that investigation?
Look, this is a really, really important point to get clear on. It's vital people understand this. While the police investigation is undoubtedly a significant development,
of course,
it's absolutely crucial not to rely on it as a direct or even guaranteed path to getting your investment funds back.
Yeah.
That's just not its primary purpose.
Okay, why not?
Because the police are focused primarily on investigating potential criminal wrongdoing. Their main objective is to figure out if any laws have been broken.
Right.
And if they find evidence, then their job is to pursue prosecution through the criminal courts. Their focus is squarely on criminal justice.
Not on financial compensation for individuals.
Not directly, no. That's not their main remit in this kind of investigation.
So let's say, hypothetically, the police investigation does uncover evidence of wrongdoing. And maybe there are successful convictions down the line. That still doesn't automatically mean investors get their money back. That's a really key distinction.
Precisely. It's a hard truth, but yes. While a successful conviction might bring, a sense of justice, maybe some closure, it is absolutely not a guarantee of financial restitution for the victims, the investors. Furthermore, any criminal proceedings, well, they could take a very long time.
Years, potentially.
Potentially years, yes.
Mm.
And even if, at the end of all that, a conviction is secured, the criminal court isn't legally obligated to order the return of funds to investors as part of that criminal case.
So that's usually a separate process.
Generally, yes.
Yeah.
Financial recovery is typically pursued through different civil channels.
And you also mentioned something earlier about a time limit for investors to take their own action. Something about the Limitation Act. Could you just remind us about that quickly?
Yes, that's another critical factor. The Limitation Act 1980, it basically sets out strict time limits for bringing most types of civil claims in court.
Okay.
Now, typically, for claims related to investment losses, things like misrepresentation, the period is usually 6 years.
6 years from when?
Generally 6 years from the date the cause of action arose.
Yeah.
That could be, for example, when the misleading statement was made, or perhaps when you first actually suffered a financial loss because of it.
Okay, 6 years.
Now, the danger here is if you simply wait indefinitely, just hoping for a positive outcome from the police investigation,
Yeah.
you run a very significant risk of that 6-year window closing.
And if that happens?
If that deadline passes, you could potentially lose your legal right to pursue a civil action to recover your losses forever, regardless of what happens with any criminal proceedings.
Wow.
So the key takeaway here is the police are not primarily focused on getting your money back for you, and relying solely on their investigation carries this very real risk of missing your own opportunity for potential civil recovery.
Okay, so that's a pretty stark warning about just waiting. So if waiting for the police isn't the main route for financial recovery, what practical options do investors in the 79th Group have right now? What can they actively pursue?
Well, what's really important for you, the listener, to understand is that while this criminal investigation is happening over here, there is a completely separate, distinct path available over here.
Okay.
And that path is taking civil action, using the tools of insolvency law and commercial law to potentially recover your investment. This is a crucial distinction.
Civil action versus criminal.
Exactly.
Mm-hmm.
Civil recovery focuses very specifically on investigating the company's financial affairs, on tracing where the money went, potentially recovering assets, on holding directors and maybe other involved parties accountable through the civil courts. And ultimately, the aim is returning funds to the investors who've been affected.
Right. And you mentioned before that the standard of proof, the legal bar, is different in civil cases compared to criminal ones. That could make a difference.
Yes, that's another key advantage of the civil route in this context. In civil proceedings, the burden of proof is based on the balance of probabilities.
Meaning,
you generally just need to demonstrate that it's more likely than not that, for instance, you were misled about the investment.
okay, more likely than not.
Which is a lower legal hurdle to clear compared to the beyond a reasonable doubt standard needed for a criminal conviction.
Which is much higher.
Much higher, yes.
Yeah.
So this can make pursuing civil recovery a potentially more accessible and maybe quicker route for investors who are primarily focused on getting their losses back.
And crucially, you've stressed that the civil action, it doesn't have to wait, right? It doesn't have to wait for the police to finish their work or for the 79th Group to magically come up with some internal rescue plan. Investors can actually move forward now.
Absolutely, 100%. Civil action can be initiated right now. In fact, at Insolvency and Law, we've already taken proactive steps on behalf of investors who've come to us.
Such as?
Well, we've already issued what's called a pre-warning letter before action. That's a formal step. And we've commenced a really thorough examination of all the potential legal avenues available under civil law.
Looking at things like?
Things like claims for misrepresentation, potentially deceit, breaches of director duties, and also looking at possible actions against third parties who might have been involved.
Okay.
Our focus is squarely on taking concrete, tangible steps now to pursue recovery for investors. We're not sitting back and waiting for external events to unfold.
Now, something else that's been discussed among investors is this thing called the lender's majority group.
Mm-hmm.
Can you just clarify how the work you're doing at Insolvency and Law relates to that group? Is there any overlap? Any potential conflicts investors should be aware of? Or are these totally separate things?
Yeah, that's a really important point to clarify. Thanks for bringing it up. Our loan note enforcement and recovery service, it operates completely independently from whatever the lender's majority group process is doing.
Totally separate.
Totally separate. There is absolutely no duplication of effort between us. There's no conflict of interest whatsoever. And investors have complete freedom to participate in both processes at the same time if they want to.
Okay. So you don't have to choose.
You're definitely not in a position where you have to pick one over the other. You can pursue both avenues simultaneously.
So an investor could theoretically be involved in the lender's majority group's activities, whatever they might be, and also engage your services to pursue their own individual civil recovery action.
Precisely. That offers investors more options, more potential routes to recovery.
Right.
Because while the lender's majority group might be exploring certain, perhaps, collective actions or negotiations, our sole focus remains on rigorously enforcing the individual legal rights of each specific investor we represent. We are committed to pursuing civil recovery and enforcement actions, using the full power of the Insolvency Act and other relevant civil laws, with the specific goal of reclaiming lost funds on behalf of those individual investors.
Right. Protecting their specific interests.
Exactly. So, look, while it's completely understandable that some investors might want to kind of wait and see what comes out of the lender's majority group discussions.
See how things play out.
Yeah. But it's vital to remember, you don't have to put all your hopes, all your eggs in that one basket. You have the legal right to take individual civil action now to protect your own position.
Okay. This has been, well, it's been a lot of quite heavy information to process.
It is.
And I can easily imagine that many people listening right now might be feeling a whole range of emotions, maybe overwhelmed, perhaps quite angry, confused, possibly feeling betrayed even.
Understandably so.
What's your sort of final message, perhaps, to those investors who are listening, feeling like that at this really critical point?
Well, I think if we just step back again, look at the bigger picture. It's absolutely crucial that you don't feel like you just have to accept this situation passively.
Yeah.
Or, just disappear quietly into the background.
Don't just give up.
Exactly. You made these investments in good faith. And you have significant legal rights that come with that. You do have options available to you. And collectively, you certainly have a voice. And insolvency and law, look, we are ready. We're equipped to help you use that voice strategically, lawfully, to pursue real financial recovery through these robust civil enforcement actions we've been talking about.
So the call to action is?
The call to action is, please do not wait indefinitely for the police investigation to conclude before you consider your own options.
Yeah.
Don't just wait for the 79th Group Limited to maybe, possibly, offer some kind of solution on their terms.
And don't wait too long because of that limitation period.
Absolutely. Don't wait until it is potentially too late to take action because of those time limits. So if you want to explore your options, understand what civil recovery and enforcement might look like for you specifically, please just reach out to us directly.
And the contact details.
The email address is investigations@insolvencyandlaw.co.uk.
Investigations@insolvencyandlaw.co.uk.
That's right. Look, time really is of the essence here. Your legal rights, they are valuable assets in this situation. We are ready to assist you whenever you feel ready to take that next step.
Okay, so just to quickly recap our deep dive today then, the key takeaway seems to be that the 79th Group Limited's recent public statement, well, it's not exactly a positive sign for investors, is it?
No, far from it.
In fact, it strongly suggests they're facing some pretty serious financial difficulties. And critically, their main focus appears to have shifted away from repaying investors and more towards just ensuring the basic survival of the business itself.
That seems to be the core message, yes.
And it's absolutely vital, as you've stressed, to understand the limitations of relying solely on the police investigation for getting your money back. And to recognize that you do have other potentially more direct avenues for action available to you right now through civil law.
Which brings us perhaps to a final thought for you, the listener, to consider.
Okay.
Considering all the information we've unpacked today, and particularly the potential limitations and risks of just waiting, what proactive steps might actually offer you the most control over your own situation moving forward?
A question to reflect on.
Definitely. It's really time to carefully consider your options and start making informed decisions about how best to protect your financial interests in all of this.